Hey everyone, welcome to our live EB-1A Visa Masterclass. I'm so excited to have this live event. People have been asking. I used to do this quite a bit about a year and a half ago. I'd have these monthly live events on the EB-1A. So thank you for joining. I hope this will be useful for you. Okay, what are we going to cover today? What are you going to learn? First, I will explain each of the criteria and provide hopefully some insight that you can't learn anywhere else. And then after the masterclass webinar, you should have a much clearer idea if you or someone you know qualifies for this visa. So before we begin, I have to put out the disclaimer. So this masterclass, this PowerPoint presentation does not constitute legal advice, doesn't create an attorney-client relationship, and we cannot guarantee outcomes. Okay, we've done the legal stuff. Let's move on. Okay, so my name is Priya Alagiri. I am the CEO and founder of the Alagiri Immigration Law Firm. We are a boutique immigration law firm, which means we're slightly different maybe from some of the company law firms that you've worked with. Boutique meaning we are very niche, we're very focused, and we're very focused on one type of visa, and that's the EB-1A visa. And we're only focused on EB-1A visas for engineers. So we're hyper niche. And I have been practicing immigration law for, over 15 years now, and worked on and thankfully have won literally thousands of cases at this point. I wanted to share some testimonials with you. These are all on our website, on Google. Please check them out. And we are so grateful for our clients that we've helped. Okay, let's jump into the meat, the substance of this masterclass. So if you don't already know, you can apply for the EB-1A visa only if you work in 5 areas. Sometimes people don't know this. So you can't even think about applying for the EB-1A unless your job falls into one of these 5 categories. So it's science, art, athletics, education, and business. So that's the first question. We handle engineers, which falls under science. But for example, like myself, I'm a lawyer, but I can't apply for the EB-1A visa. It doesn't cover lawyers. So be careful. Not everyone who's extraordinary or highly accomplished can apply for the visa. Okay. So let's say you fall under one of those 5 categories. You're under the science category. You can qualify right off the bat for the EB-1A visa if you have received a one-time major award. And here are some examples, Olympic gold medal, a Nobel Prize, an Oscar. So if you received a one-time massive, major, internationally recognized award, like those examples, you can qualify for the EB-1A visa. It's kind of one and done, and hopefully you'll get approved. But if you don't have an Olympic gold medal, or you don't have one of these major international, awards, you can still apply for the EB-1A visa. And that's most of us, right? So if you, again, don't have that major award, you can qualify if you meet 3 of the below 10 criteria. And I'm going to run through the criteria. So, first, awards. So, this is different than those global major awards, like the Oscar, Nobel Prize. This is lesser known awards. So, if you received awards, it for excellence in your domain, in your field, you could potentially apply. School awards don't count. USCIS doesn't really accept anything university related. And they also don't accept awards that are not like in a public, like competitive format. So it doesn't really need to be open to the public, but at least it's open to competition that's broader than your company. But what I wanted to share that I've learned over the last year now, because so many things have changed with the new government, is that they really don't like awards at all. Unless you can make a super like strong argument. I honestly, and you know, we have a lot of clients who've received awards that are really highly prestigious, but we don't argue the awards criterion that much anymore because it's just not really accepted by USCIS lately. Okay, second criterion, published material about you. Lots of confusion about this criterion. Published material about you means that you've had some type of article or some type of, I don't know, an interview, digital content that's been published, but it has to be about you, not your achievements. So this criterion is very, very strict. So what would count is like an interview with you, and it should be with you. It should mention your name. It could talk about your achievements, but the focus of the interview or the material has to be you. And the other piece you have to know is that it has to be published in a major platform, major media platform. You'll find as I go through these criteria that most of them have 2 prongs. So this one is the published material has to be about you. And then secondly, it has to be in a major media platform. Okay, number 3, membership. So I put it in here, but in the last year, again, what we've learned from the new government is they really don't like this criterion. We used to have lots and lots of success with membership previously. But now over the last year, it's just USCIS is not accepting it or approving it. So, I mean, I would think twice about including membership in your application. If you do, be prepared to provide like official documentation regarding how you were selected to be a member. And of course, you have to be a high level of membership, not the paid version. But it should be official documentation, not a letter, not screenshots, nothing like that. They want like even like bylaws, documents like that. And then also what's come up this year and not before is they also want proof that experts are evaluating your membership selection. And again, they want like official documentation. So I would think twice. And if you do apply under memberships, make sure you're able to provide that in, those 2 at least pieces of evidence. I'm kind of flying through here because I want to make sure we cover all of this, but I also want to get to your question. So I'm just giving highlights on the criteria for now. So the 4th criterion, judging the work of others, is probably one of the more flexible criterion. And it includes more things than you think. So if you're reviewing work product, even internally, if you are assessing, evaluating some type of, I don't know, technical document, or even if you're doing assessments of work performance, that could count. And we've had quite a bit of luck with this criterion. Again, it is one of the more flexible ones, but you have to make a good argument. So yeah, I would say this one and maybe one other criterion, which we'll discuss in a few minutes, are probably the most flexible criteria for the EB-1A. Okay, moving along. Number 5. Okay, original contributions of major significance. This is a really critical, really crucial criteria for the EB-1A. I've never seen an EB-1A approved without this criterion. And again, we just work with engineers, so I'm just talking, everything I'm saying today is just focused on, engineers. So, and there's a lot of confusion about this criterion. I want to spend just a little more time on it. So if you remember in the beginning, I talked about those 5 categories that you have to fall into. You have to fall into sciences, business, athletics, education, arts. So these criteria that I'm going through, it's the same for all of those 5 categories, right? So there's a lot of confusion. So what an original contribution is for a movie star is entirely different than what an original contribution is for an engineer. Okay, but I can say I'm very confident that this criterion is pivotal to get an approval of your EB-1A. And there's 2 parts to it. Again, a lot of these criteria have 2 parts. So you have to have a novel contribution, which means for the engineering space, it has to be a unique technology. It has to be a novel invention. You don't need patents, but it should be the way the Immigration Service has explained it. It's a technology, a methodology, a technical type of contribution. So that's the original part. The second part, it has to be of major significance in your domain. So major significant means it has to be in use. It has to have had some kind of impact, some kind of influence in the field, commercialization, just others using your work. Of course, patents. You don't need patents, but that's one way. Especially if someone has cited your patent. So keep in mind, contribution for engineers means an innovation, a technological innovation. Okay, moving along, scholarly articles. So this one is pretty self-explanatory, but the one thing I want you to know is that a scholarly article for the EB-1A means a technical paper, like a white paper, a paper written for other professionals, like your colleagues in the field. It's not something you write and it's published in like a magazine and someone like me could understand it, or it's really like a technical, scholarly, in-depth paper that you've written, should have your name on it, and it's published in a well-known platform. Okay, conference presentations could qualify as well. Okay, moving along. Critical and/or leading role in a distinguished organization. Okay, again, this is actually 3 parts. This criteria actually has 3 parts. Okay, you could have a leading role, or you can have a critical role, and the third, it must be in a distinguished organization. So We've gotten definitions from the Immigration Service. Leading role means supervisory, managerial, like direct reports. Critical role means that you are working on critical projects or something crucial for the company. So usually independent contributors fall under critical role. Some are both, some applicants have a leading role, meaning they're managers, they have direct reports, and they also carry out, crucial functions and projects and initiatives for the company. So, and then the third, it should be in a distinguished organization. The way the Immigration Service defines distinguished is, kind of these very, I would say in this archaic way, like, size, how long, the company has been established, kind of this brick and mortar way of thinking about things. But, you have to just make your argument if you're not working for one of those, really well established, been around for hundreds of years companies. Okay, moving on to high remuneration. This is a criteria that I think that the second one that I mentioned that's a little more flexible because the Immigration Service hasn't told us what would be considered high. So you have to make your case. And you make your case by comparing your wage to others in the field, right? So that's why in the bullets, I say, choose your occupation, choose your title and position in such a way that optimizes you. We have to, so once you solidify your occupation, you look, compare the wage for that occupation to other, to wage data surveys. You don't have to just take into account your base wage. You can include your total comp, but you always have to do an apples to apples comparison, right? So if you're using your base wage, you have to use wage data that only uses base wage. Okay. Again, like each of these criteria, like could be its own, masterclass. So I'm kind of flying through because I want to get to your questions. These last two criteria are really not for engineers. I just wanted to include it because they are part of the 10 criteria. This is work that has been displayed at exhibitions or showcases. So the reason engineers could not qualify for this criterion is because it's restricted to artwork. And I mean, USCIS has said it. So it's more for those people in the arts. And then the last criterion is commercial success in the performing arts. So again, this is more for people in the artist category, movie stars who have movies and then things like that. They have to show success in the commercial, in the commercial way. Okay. So meeting 3 of the criteria is just the first step in a 2-step process. And many of you may already know the second step is called the final merits analysis. Unfortunately, we don't have time to cover that in this masterclass. But hopefully we'll have another masterclass and we'll discuss it. But you have to meet at least 3 of the 10 criteria in the just to even think about the EB-1A filing. Okay, so we would love to help you decide if you qualify for the EB-1A don't hesitate to reach out to my office. You can call, email. We have lots of avenues for contacting us. So I hope you reach out. And yay, great. I've covered everything, and let's open it up to some Q&As. Okay. So, hello. Thank you for joining, everyone. Okay, so we got a question about a patent. Can a patent exclusive be considered for scholarly articles criteria? So can a patent be considered under the scholarly articles criteria? No. And I know why you're asking, actually. So, when you publish a patent, because the terminology is it's very confusing, and it's the same type of terminology over and over and over. So when you publish a patent, you have to have like a publication for the PTO. That patent publication is not a scholarly article under the EB-1A. So if you wanted to use your patent, you would use that under original contributions. That's a good question. So we have a question about submitting. How many peer reviews do you need for the EB-1A? So this question is about peer reviews for the judging criterion. So one of the ways to meet the judging criterion is reviewing papers, right, for journals or conferences. And how many do you need? So again, like the Immigration Service doesn't give us a number. If you just have one, it kind of stands out as strange, I guess, or it would appear, if you just have one, that maybe you just did that one to meet the judging. So I would definitely do more if that is something you do, and it just should be it should be seamlessly integrated into your entire profile. So next question is about how many technical innovations are required. So again, this goes to the original contributions criterion. Again, Immigration Service doesn't tell us how many. I think the way to think about all of this is that it's your story, it's your narrative. Does it make sense? If you have one original contribution, we've gotten approvals with just one. So of course you definitely can, but you have to have like the narrative around it. What did you do before? Did you have related accomplishments in your field? What did you do after? So one is fine for the original contribution. Should be super strong. Like I mentioned, it should be, you have to prove that it's a unique innovation. Someone is asking about an optometrist for the EB-1A. I mean, you can convince, again, you have to fall under those 5 categories, which, if anything, you would fall under sciences. You have to make an argument. It's not our area. We do engineers. So you would have to, if you could make an argument that it falls under the sciences, talk to a lawyer, immigration lawyer that has experience with optometrists. Next question. how many citations is generally considered worthy of using. So, okay, we've gotten, I would say actually almost all, like a vast majority of our approvals, our clients didn't even have patents. Okay, so you don't need a patent. If you do have a patent, that's an extra layer of authenticity. So if you don't need patents, you don't have to really even have patent citations, right? So there's not a number um, of citations. You have to explain beyond the patent, like what is so unique about your invention, why it has, how it has impacted your field. Um, that's much more important than saying, oh, you have citations, because the Immigration Service, again, in the last year, has really won't just won't just accept a patent on its own. They just won't. They've stopped doing that. They'll say, oh, we know you have a patent, but so explain your technology, explain why it's important. Okay, a question about wage. Okay, that's a good question. This question is, do performance bonuses count? No. If you're using ONET or BLS, performance bonuses don't count. There is like a fine, like you'll see like the fine wording. If you go to look at what the ONET or BLS, which means the Department of Labor data, like what is included, it's when they talk about performance or bonus, they're more talking about commissions, not what you're referring to. So if you're using ONET, you have to use your base wage. No bonus, no RSUs. But you can also, you don't have to use ONET or Department of Labor data. You can use private wage surveys. Okay. So another question. We have a few more minutes. Would past technical innovations count? So this is the thing with the original contributions criterion, and the Immigration Service, very often, gets confused on this criterion. So past, yes, of course. An original contribution is original contribution, no matter when you made it. So if you want an original contribution and it was implemented, remember there's two parts to that criterion. You developed a novel innovation and it was implemented. And if someone developed something after you, great, but you still had a novel innovation when you created it. So you just have to explain, and I definitely wouldn't explain to the Immigration Service that if it has been deprecated, there's no need for that. You had an original contribution and it was of major significance. Okay, let's see something. Okay, this is more of like an administrative question regarding the LORs. So LORs meaning letters of recommendations from experts, and that's another whole masterclass on its own. I didn't cover it here because there's a lot to talk about. So letters of recommendation. The question here is, do you need the company logo? And the answer is no, you don't. In my I don't know, 15 years, I think maybe once or twice we actually had a company logo. And that's because These are for self-petitioners. That's because it's a private, that person is writing as a private recommender, right? He or she is not writing on behalf of the company. You know, he or she is explaining what he or she has personally seen. So you don't need the logo. You do need to have a lot of other information, but not that. A question, I think this will be the last question. Does writing a best-selling book count as an original contribution? And I can tell you that USCIS has been very clear that the answer is no. So if you're an engineer, again, this is all for engineers. For an engineer, an original contribution is not a book. It's not a book chapter. It's a technology. It's an innovation. It's a technical methodology. What your book could possibly qualify under is scholarly articles, if it meets that criteria. But yeah, there's so much confusion out there regarding, you know, people think a book is a contribution. It's not. And I've heard that directly from the Immigration Service. Okay, unfortunately, I have to cut it off. Thank you so much for attending. I hope to do this again, and look forward to more information from me on our YouTube channel. Bye, everyone. Have a good day.